Mr. Hrdlicka and Ms. Ashby, I see you both in the virtual courtroom. So Mr. Hrdlicka, we're ready when you are.
Yes, Your Honor, may it please the court. My name is Michael Hrdlicka. I represent Katie Renner. I'd like to reserve 5 minutes of my time if I could.
Very good.
This case involved 4 distinct issues that all happened at different various levels of the trial court's proceedings. The first was a motion to reveal a confidential informant or to take an in-camera hearing of information the confidential informant may have. The second was the judgment of acquittal arguments that the defendant made at the trial. The third was the jury instructions issues that the defendant raised at trial. And the last was a sentencing enhancement that was imposed by the trial court judge. In regards to the way that this case came down, it was a transaction that occurred at a residence that was entirely set up by the confidential informant. The confidential informant was a person that was being utilized by law enforcement in order to target Ms. Renner, and as well to set up an introduction between Ms. Renner and a law enforcement officer who was going to handle the transaction. But none of the conversation that preceded this event, none of the text messages or phone messages that supposedly happened between Ms. Renner and this confidential informant were ever recorded or monitored in any way by law enforcement officers. And so essentially what happened was the undercover officer arrived on scene at this residence without having any sort of knowledge, personal knowledge of what was going to occur there, other than what I guess the confidential informant must have told him. He arrived on scene. He was wearing a device. I see Judge Morris talking and I can't hear him. I don't know if he's...
You are
about that. Let me try it again. Thank you for the help.
Yeah, no problem.
Thank you for helping me interrupt you.
Yeah, right, exactly.
So as I understand it, what's going on here is the CI makes the introduction. But the transaction itself, the CI stood in the doorway and watched, but was not otherwise involved. Is that a fair statement? I
think there's a time in which the CI is in the doorway and the detective is in the room with Ms. Renner. But immediately prior to that, Ms. Renner had been alone with the CI, and due to the issues that are involved with the recording of it, there's no audio, there's no real way for the court to know what was said in that discussion. So I think while it's fair to say that yes, that when the transfer of the narcotics took place, the CI is in the doorway, it's unclear from the record what role the CI really played in setting up the transaction or what kind of active participation.
But help me understand how that matters, because the introduction was made by the CI. The transaction occurred without the CI's involvement, but merely as a standing in the doorway watching. You know, what we know is this undercover officer was ushered into Miss Renner's bedroom. She was sitting there. She had the controlled substance on a scale. She weighed it. She took his money, gave him the controlled substance, and the CI had no involvement in any of that, except for to set up the meeting.
And I would agree that the CI had no real involvement in the actual physical transfer of the narcotics, but we would argue she's still an active participant in setting up, negotiating the amounts. You know, obviously there was a transfer of narcotics from what it appears from another person. We don't know her knowledge of that or what her role in that transfer was, whether or not there was some sort of deal between her and those other people. We don't know. And that was the whole basis for the motion to reveal, in the sense that we have to establish either that it would be useful to a defense or that it's necessary for the fair determination of the trial. The first would be whether or not we would be able to establish any sort of potential defenses. Entrapment was one of them, but there's also the defense of temporary possession. And that was argued at the trial level. And obviously the CI's knowledge of what Ms. Renner's knowledge there would have been important to us and could have been illustrative in terms of what Ms. Renner knew or what control she had over the narcotics.
But at the end of the day, aren't you what you're arguing is basically, hey, maybe the CI would have relayed a different story about how the drug transaction went down than what the detective did. Isn't that basically your argument?
I think that there are two arguments, is that she obviously has more knowledge than the detective, so she would have been able to give more information in terms of how the transaction took
Why
place.
obvious? The detective was at literally an arm's length transaction, and this watched Ms. Renner do the weighing, took the baggie himself into possession, handed her the cash. Why is it obvious that the CI would have more information about that than the detective that testified?
Because the detective wasn't participant in how the transaction was set up.
He was literally a party to the transaction.
But he didn't negotiate the amounts. He didn't negotiate the place. He didn't negotiate the price.
And why does that matter?
Because that's all a role and an active participant that the CI took.
Right. I mean, which that's kind of just that's a self-referential explanation, because it is. I mean, help me out, unpack it a little bit. Why does that matter to the charges that this jury was charged with adjudicating?
Because essentially, Riverio says that if a CI takes an active participant role in the transaction that took place, that they have to be revealed in order for the fair determination of the trial. That's kind of what part of our argument would be. We don't know what was said to make this transaction take place. We don't know what was said between what parties. Obviously, there's a video that shows what occurred in the room, which we've talked about, but we don't know in terms of how we got to that position. When that would go into the charge of trafficking in terms of what her knowledge of the amounts were, what her knowledge of the ability to control that was.
But Riverio does not invite an open-ended inquiry because defendants or defense counsel thinks it would sure be nice to know who the CIA is and what they know. I mean, it's tied to a discrete defense. Help me out. What is that defense, and why does what the CI knows or might have known pertain to that defense?
Well, Riverio has two ways. The first being if it can be helpful with the defense. In the defense of there potentially would be entrapment. We don't know what was said to get Ms. Renner there. Ms. Renner could have potentially been entrapped in order to have her appear there at that residence, engage in that transaction. The other defense would be the defense of temporary possession as laid out in Hamilton. We don't know what Ms. Renner's ability to control the narcotics was in this. We don't know what her understanding of the transaction was. In Hamilton, there was essentially a middleman that occurred. The middleman was found not to be guilty of the crime in Hamilton because of the same instance that happened here in Renner. That's the defense that would potentially be there. Riverio doesn't say that Ms. Renner has to have proven that defense was available entirely, that all the elements of that defense occurred. Riverio just says that defense has to have been available and that the CI's testimony would go to assist in that defense. And I think that was discovered on the trial court level and was there at the hearing, and obviously was an issue there later at trial. And that goes kind of into the argument as far as the judgment of acquittal as far as trafficking. There was no evidence in elicited, substantial, competent, or otherwise, that Ms. Renner really knew the amounts that were alleged in this case.
Mr. Herdlicka, the testimony included that your client weighed the drugs, correct?
The testimony included that when the officer entered into the room, the drugs were on a scale.
And the scale was in front of her, right?
Right.
And no one else was in the room other than the detective at the doorway and the defendant?
At the time that the detective was in the room, yes.
The detective testified that she weighed the drugs, correct?
I think he testified that the drugs were on the scale. I think he testified that they were already there.
Well, but he did say that the scale had the amount showing and that he retrieved it from the scale, didn't he?
Yes.
Okay. I just want to make sure I understood it. And then he actually took the drugs off the scale.
He's the one that took the drugs off the scale, yes.
Very good. Thank you.
And
actually, Mr. Herdlicka, his testimony was she weighed it and put it on a scale.
And I think in cross-examination, I think he further clarified that he never actually saw her touch the narcotics. And so
but does that does that change the fact that he's testifying that she weighed it?
I suppose we're splitting hairs, but the reality is it has to be substantial or competent evidence.
It's a JOA argument. I mean, you gotta you gotta worry about those hairs.
I agree. Ultimately, as far as the trafficking goes, there's nothing to suggest that even if she did weigh it, that she was anything more than a temporary person or go-between between the Ortiz person that supposedly appears to have brought the narcotics, Markley, who was also there and present, and the detective. There's nothing to suggest that she profited from this engagement, that money actually went directly to her. There's nothing to suggest
Are those inferences that the jury is entitled to draw from the facts that were presented at trial?
Yes, I believe so.
Okay.
But I also think that they point out a lack of evidence in the state's case as far as their case in chief, and the fact that none of that evidence was presented, nothing tied her to the transaction other than her being physically present. I think there's also an issue as far as...
I did want to go back because I was double checking the transcript, and the officer testified that he saw, after she weighed it, he saw it was the amount that, quote, it was the amount that we wanted, and I gave her the money and completed the transaction. Isn't that enough for the jury to infer that she knew what the amount that was being weighed was and the dollar value that was being exchanged for it?
That really is the knowledge of the detective in terms of what he wanted. I don't know if that means anything in reference to Ms. Renner's state of mind.
Okay.
As far as the other charges that were at hand, there was the possession of drug paraphernalia, which really ties into the other arguments that we've made as far as the trafficking argument. But there's also the charge of constructive possession of a structure used for the manufacture or sale of narcotics. In this case, obviously, the crime occurred in a residence, but there was nothing to suggest that that residence was primarily used for the sale of narcotics, that that residence was routinely used for the sale of narcotics. I think that there was enough to show that the residence was connected to Ms. Renner in some manner. But other than the fact that it occurred there wasn't anything to show that it was mere happenstance that the location was anything other than the fact that she resided there. There was nothing specific about that residence that seemed to suggest that it was more suited
But she
for
just happened to
narcotics
have a
transactions.
scale there. So what else do you think she would be using that scale for?
I think that there obviously scales are sewn. They're not necessarily drug paraphernalia. You can use them to weigh.
Well, I mean, other than standing on a scale and weighing yourself, I'm drawing a blank on what else I would normally weigh in my household with a scale.
People use scales to bake. People use scales to bake. People use scales for a large other variety of innocent conduct. The reality that just because a scale is present in the house means that all of a sudden that house is used.
Well, it
for the
wasn't
purpose
just
of
because it's present, it's because it was used in this transaction that I think, it was used for measuring drugs that were about to be sold, and they were sold in a quantity that equals a trafficking amount. So, that's why you have to ask that question. So, you've raised some good points for cooking. I never thought about that one. Can't say that I've ever weighed anything when I've cooked, but maybe somebody has.
It's supposed to be more accurate.
Going to Judge Morris's point, I mean, couldn't the jury take the overall transaction and how this total stranger is basically invited into this residence based upon nothing but an introduction from a CI, take that in, and as well the evidence that this person apparently keeps a scale in their bedroom, and it doesn't sound like the kind of scale that you weigh yourself with. Take that in together with everything and the way that the transaction played out, and say, yeah, this looks like a house, a residence that's being used for the purpose of trafficking illegal drugs.
Well, in Morris, which is the case we cited, Morris involves a traffic stop with a trafficking amount of narcotics in the vehicle. And I think it's similar to this case in the fact that just because you find the implements of trafficking in a vehicle or in a house does not mean that that vehicle is used for those purposes.
Sure.
Obviously, it's distinguishable in the fact that a sale occurred in this case, whereas Morris was a traffic stop. But I think there has to be more shown to connect the residents here to the act of either manufacturing or trafficking or sales than just simply the implements and the objects found in the house itself. There was no testimony presented from the officer that they had seen surveillance of vehicles there for a short time. There was no testimony from any officers that they had seen other transactions, anything along those lines that would connect the residents to actual sales, more than just the one instance that occurred here. And that in one instance does not mean anything more than particularly a happenstance. And that's what we would argue. That's what we argue at the JOAs, and that's what we argue here today.
But certainly there's enough evidence for it to go to the jury. I guess your fault is that the jury found in a way that you didn't want them to find, and now you're asking us to reweigh that evidence, which you know we can't do.
Well, I think what we're asking is to find that the fact that it went to the jury in the first place was like in Morris, in which there was nothing more than just the items there. And in Morris, that conviction was overturned.
Mr. Hurdley, you've used 15 minutes, so if you want to reserve your 5, you should do so now, but you're free to go forward if you wish.
If I could just briefly touch upon, obviously, the jury instruction argument, I think ties into the arguments that we've made as far as JOA, similar arguments, similar law. They were both accurate statements of the law. The standard instructions were silent on those issues. And finally, as far as the sentencing, we just argue that the evidence that was produced at trial did not fit the enhancement. That's all, Your Honor.
Very good. Thank you very much. Ms. Ashby?
May it please the court, Katie Ashby for the state of Florida. In seeking identity of the CI, appellant had the burden of demonstrating that the disclosure would be either relevant or helpful to the defense or essential to a fair determination of her cause. As the record reflects, she failed to do both. The first component necessarily centers.
He's raised the issue, which is an interesting issue. He basically says, you know, we were arguing that she was entrapped, and without what the CI would have to say about this whole thing, there's no way that we can really, you know, defend on that. We can't really know. Respond to that for me.
So the appellant has to make a preliminary showing of colorability, which means that the appellant's not only required to allege the legally recognized offense in their motion, but support it with the sworn affidavit. Appellant's affidavit in this case did not support entrapment. In fact, she denies having ever committed the crime. She claimed that she was neither involved in the negotiations leading up to the transaction or even the transaction itself, and accused her boyfriend of basically stealing her phone from her and negotiating and completing the sale. And absent these sworn allegations of a legally cognizable defense, the court was without authority to order disclosure. And as to the other argument that the disclosure of the CI was relevant to prove a lack of dominion and control, the affidavit likewise did not allege any relevant facts regarding to the CI's involvement, and thus did not show that it would have been relevant or helpful.
Can I shift gears on you in a second? I want to shift gears to the point, again, your opposing counsel made about whether the house was used for drug trafficking or not. He makes a pretty good argument. All we really got is this one transaction. There's not a lot of testimony about the fact that the house was watched and cars came and went and all sorts of things were going on. It looks like that the sole really piece of evidence is this one transaction. How do you respond to that?
So looking at Morris, there has to be a sufficient nexus between the sale of the methamphetamine and the residence. And
so is
Morris,
one sale enough?
It is a safe position that it is. And based on the facts, we have, when the officer and the CI arrive, we have her welcoming them into the home, informing them that her supplier is running late. Then we have the officer sees her texting, necessarily doesn't know who she's texting, but based on the fact that immediately after she goes, oh, he'll be here in a few minutes, we can infer that she's having a conversation with her supplier. When the supplier arrives, he goes back into her bedroom. And then the sale is also conducted in her bedroom as well.
I don't think there's any issue about that. I mean, I think it's pretty clear that that happened in her bedroom and she didn't make any bones that it was her bedroom. you know, my greater concern is there enough other evidence to demonstrate that this house was used for trafficking? And it sounds like all we have is this one transaction, and the fact that, yes, it did occur in her bedroom, and yes, she was talking to a supplier, which may have supplied her from her car up into every transaction prior to this one. We just don't know, do we? So we have to get comfortable with the fact that we got one transaction here and that's all. Is that right?
Right. And we have to show that she knew that the residence could be used for trafficking of the controlled substance. And in here, of course, she did, surely she knew she was actively involved in the transaction itself. So yes, we only have one, but I think, you know, especially since we're looking at a JOA argument, I think that the state did set forth enough evidence that it would be proper to bring it to allow the jury to resolve that issue. In issue 2, the appellant also argues that the state failed to show dominion and control. However, it's the state's contention that we have presented enough evidence from which you can kind of infer that she actually possessed the drugs. The officer's
knowledge of precedence and ability to reduce to dominion and control is all you got to show, right?
Correct, Your Honor. And in this case,
and this scale was literally right in front of her, wasn't it?
Yes, it was on a bench directly in front of her within arm's reach. Okay. The officer's testimony says that he saw her pick it up and weigh it on the scale and then engage in the transaction, accepting the money and allowing the officer to pick it up. And then as to weight, as the Florida Supreme Court acknowledged in Way, knowledge of weight is not an element of trafficking, and thus it doesn't need to be proven by the state. And while the state does not need to prove that, the evidence here does support that she was aware of it, based on the fact that, as the officer testified, he couldn't remember exactly what the weight was on the scale, but that it was the agreed upon amount. The scale is directly in front of her as well, so you can reasonably infer that she was aware of that amount.
And she did receive his money, which she was satisfied with, and you know, that money was calculated on the quantity of the substance, of course, how they are, right? I mean, do we know that, or do we have any evidence of that? That the amount that was tendered was calculated and determined based on the quantity of the substance. I mean, we kind of intuitively know that, but do we have any really evidence on it?
So the officer did testify that the amount on the scale was the agreed upon amount, and that he provided the agreed upon dollar figure for that amount. I don't know.
Well, we got to make a lot of jumps to come there, right? I mean, we don't have any direct testimony that walks us from the beginning to the end on that little scenario, right? We have to surmise, don't we?
But to infer. But regardless, knowledge of the weight is not an element. All the state had to show was that she knowingly possessed this amount, and that the amount was a trafficking weight. In this case, after the sale, it was confirmed to be over 31 grams, which is a trafficking amount. As to issue 3 of the jury for jury instructions, the state's position that the appellant failed to establish entitlement to the proposed special instructions. As to the incidental temporary possession instruction, it's the state's position that it is an incorrect statement of the law and not supported by the evidence. The request for this instruction was based on the Hamilton case, which was limited to those specific facts. In that case, Hamilton was merely possessing a controlled substance from the owner or seller to the buyer and didn't establish power or intent to control it. This case is factually distinguishable. This isn't a case where the appellant's merely passing drugs in the presence of its true owner who can assert dominion and control over the contraband, but instead we have an actual transaction where both the boyfriend and the supplier were no longer in the room. The only 2 individuals in the room were appellant and the other undercover officer. When he walks in, he testifies that she is directly in front of the scale, that she is seen picking up the substance, weighing it. And based on her actions, we can see that this was anything but an incidental possession. As to the weight instruction, this is also an incorrect statement of the law. As we discussed earlier, weight explicitly holds that knowledge of weight need not be proven to establish trafficking of a controlled substance under the statute. The term knowingly only modifies the possession element, not the quality element. And finally, as to the last issue, the drug trafficking enhancement is supported by the facts that were established at trial. As previously established, the testimony and the body cam footage were sufficient to establish the appellant's involvement in the transaction and met the element of the charged offense. Because the evidence supported the jury's verdict, the trial court had the discretion to imply the enhancement. The sentence is therefore legal and should be upheld. If this court has no further questions, the state will rely on its brief and ask that this court affirm the appellant's judgment and sentence.
Thank you, Ms. Ashby. Mr. Herdlicka.
Just briefly in rebuttal, I think the issue involving the motion to reveal CI really comes down to the determination of whether or not the affidavit established enough for defense, or whether or not that the CI was an active participant in this case. I think we've kind of gone over the defenses in terms of whether or not that they were there. I do want to point out in case that we didn't really bring up before, Suhu, the case cited in our brief, really goes to the issue of an uncontrolled CI that is not being monitored, not being supervised by law enforcement. I think the evidence that was presented on the trial level indicated that this confidential informant was not being supervised, was not being monitored, had successive conversations with somebody. We don't know who, we don't know what was said. That was a potential entrapment defense that was there, that was presented at the trial level. I think the evidence also shows that the CI was an active participant, clearly in setting it up, a role that the undercover officer really didn't take. The undercover officer really just showed up, handed the money, got the drugs after waiting for some time. It's clear that the evidence suggests that the CI is more of an active participant than the undercover officer was. Other than that, Your Honor, I have nothing else to add.
Very good. Thank you both very much. You may exit from the virtual courtroom, and we will proceed to the next case, which is Jaramillo versus Jaramillo.